This is Democracy Now!, democracynow.org, The War and Peace Report. I'm Amy Goodman with Aaron Maté.
We turn now to what could be one of the most significant press freedom cases in decades. The Supreme Court has turned down the appeal of a New York Times reporter who faces prison for refusing to reveal a confidential source. James Risen had asked the court to overturn a ruling forcing him to testify in the criminal trial of ex-CIA analyst Jeffrey Sterling. Prosecutors believe Sterling gave Risen information on the CIA's role in disrupting Iran's nuclear program. In his book, State of War, Risen showed that instead of hampering Iran's efforts, the CIA effectively gave Iran a blueprint for designing a bomb. Risen vowed to go to prison rather than testify and was hoping for Supreme Court intervention. But on Monday, the Supreme Court refused to weigh in, effectively siding with the government. Risen said in response, quote, "I will continue to fight." He is no stranger to challenging the White House. In 2005, Risen helped expose the domestic warrantless spying program despite Bush administration efforts to kill the story.
The Obama administration must now decide if it will try to force Risen's testimony and risk sending one of the nation's most prominent national security journalists to jail. President Obama has already developed a reputation as the most aggressive in history when it comes to targeting whistleblowers. Obama's Justice Department has brought 8 cases so far, more than all previous administrations combined. For more, we're joined by 2 guests, Trevor Timm, co-founder and executive director of the Freedom of the Press Foundation, as well as Matthew Cooper, a reporter for Newsweek. He earned national attention when he refused to name his sources in his reporting on the outing of Valerie Plame as a CIA agent. We turn now to Trevor Timm. Your response to the Supreme Court decision not to hear the case, Trevor.
Well, I think it was really disappointing on a number of levels. You know, this decision by the Fourth Circuit before it even got to the Supreme Court was one of the worst press freedom decisions in decades. You know, not only was the government arguing that James Risen didn't qualify for reporter's privilege, they argued that reporter's privilege did not exist at all. And they even went as far as to compare journalists protecting sources to journalists receiving drugs and refusing to testify about it. So it was really disturbing on a number of levels. And the Supreme Court essentially sanctioned the Fourth Circuit ruling, meaning that in the Fourth Circuit, which is the home to countless national security sources and national security journalists, that reporters have much less protection than they've ever had to report on stories that, as we've seen over the past year, are really vital to the public interest. So, hopefully there are other avenues to continue to protect reporters' rights and allow them to protect their sources, but this was definitely a setback.
Matt Cooper, your response to this Supreme Court decision.
For transparency and whistleblowers and freedom of the press, and it shouldn't have been brought in the first place. I am frankly relieved, though, that the Roberts Court did not take this case, for I fear had they taken it, they would have come up with a ruling that would have lasted for a generation, that would have been much worse than the current state we have now. I don't think there's any sign that the court would have taken the case and delivered a resounding victory for the press and whistleblowers. No, I think really the only hope at this point, and there is a glimmer, is that Eric Holder's Justice Department will refrain from prosecuting Jim Risen for contempt of court. The Attorney General, in a meeting with reporters last week, seemed to hint as much, and that's about all Jim Risen can lean on at the moment.